And greetings. Welcome to Making Your Case, the Art of Persuading Judges, Part 2. And we're going to be going over the continuing part of this book from Anthony Scalia and Brian Jennings. Let's see, who was it again? We'll also have Black's Law Dictionary. And let's get right to the book here. Trying to remember the name of the author here, the other author. Forgive me for a moment here. And it's Brian Garner. Brian A. Garner and Antonin Scalia. Let's proceed. So we left off last time on Part 5. Pay careful attention to the applicable standard of decision. The separate issues involved in your case may be subject to varying presumptions and burdens of proof. Before we go any further, I just want to remind everyone that this broadcast is strictly for entertainment and educational purposes only, not to be used construed for anything legal, lawful, financial, or for your professional, personal life in any way. This is not to be used for anything other than for its intended use of education and entertainment here on YouTube. Don't do this at home. All right, let's continue. In a criminal trial, the prosecution must establish guilt beyond a reasonable doubt. An adversary who seeks to overturn the judgment you obtained below on the basis of an erroneous jury instruction to which there was no objection must establish not just the error, but the plain error. An appellate who attempts to set aside federal agency action as contrary to statutory authority must often show not merely that the best reading of the statute favors reversal, but that the agency's reading is not even within the bounds of reason, and so forth. So good examples here about different separate issues that are going to be varying presumptions, burdens of proofs, etc. When the standard of decision favors your side of the case, emphasize that point at the outset of your discussion of the issue, and keep it before the court throughout. Don't let the discussion slide into the assumption that you and your adversary are on a level playing field, when in fact the standard of review favors you. Say, for example, that you are asked, in a case involving review of federal agency action favoring your client, whether you don't think an interpretation of the statute different from the agency's makes more sense. You should respond somewhat as follows. I don't think so, Your Honor, but it really makes no difference. The question here is whether the agency's interpretation is a reasonable one, not whether it is the very best. And on that point, there is little room for doubt. Nice. So let's break this down really quick here one time. As the statement goes here, it says, I don't think so. It starts out with that. That's a nice one. So it's you're asked in a case involving a review of a federal agency action favoring your client, when you don't think an interpretation of the statute different from the agency's makes more sense. You should respond somewhat as follows. I don't think so, Your Honor. Nice. But it really makes no difference. So the irrelevancy here. The question here is whether the agency's interpretation is a reasonable one, not whether it is best. And on that point, there is little room for doubt. So this makes it easy for the judge. Very good. Remind the court of the favorable standard of review in your summation. Appellee's briefs commonly treat the standard of review in boilerplate fashion If your opponent is fighting against a clearly erroneous or arbitrary and capricious standard, make a big deal of it. Point out that the appellant is attempting to retry the case, or to have the Court of Appeals substitute its judgment for that of the district court or agency. Say this explicitly, not only in your standard of review section, but in your introduction and summary of argument. So appellate briefs are a whole different ballgame here. They call it brief, but they're not short. Maybe compared to these characters here, but let's continue. When the standard of decision is against you, acknowledge the difficulty, but demonstrate concretely why the standard is met. Go beyond mere repetition of stock phrases. For example, if you're arguing that the judgment below was clearly erroneous, it does little good to say, here, one does indeed have a definite and firm conviction that a mistake has been made. Cite a case in which an appellate met that standard and compare it to your own. Good instructions here. The standard of decision is particularly important. Here we're talking about, again, the standard of decisions. What standard are they using for making decisions in cases, depending on the court? It's particularly important when you're selecting the issues to pursue on appeal. Appealing a minor error that will be reviewed under an abuse of discretion standard will probably do nothing but divert time and attention from your stronger points. Sometimes, too, you can escape or neutralize the more lenient standard of review by framing your claim differently, as by arguing not that the lower court abused its discretion, but that it made an error of law in considering certain factors. Remember, judgment is supposed to be done through considering factors that are admitted as evidence and through a logical and reasonable process. Never overstate your case. Be scrupulously accurate. Once you have worked long and hard on your case and have decided not to settle, you'll probably be utterly convinced that your side is right. That is as it should be. But the judges haven't worked on the case as long or probably as hard, and are likely initially, at least, to think it much more of a horse race than you do. That will be true in any case, but especially when discretionary review has been granted to resolve a divergence of views in lower courts. You'll harm your credibility. You'll be written off as a blowhard if you characterize a case as a lead pipe cinch with nothing to be said for the other side. Even if you think that to be true, and even if you were right, keep it to yourself. Proceed methodically to show the merits of your case and the defects of your opponents, and let the abject weakness of the latter speak for itself. All right, if everyone can still hear me well, please let me know in the chat so I know I'm broadcasting loud and clear to the YouTube world. Nothing, perhaps, so detracts from the force and persuasiveness of an argument as for the lawyer esquire to claim more than he is reasonably entitled to claim. Do not stretch cases cited and relied upon too far, making them appear to cover something to your benefit they do not cover. Do not try to dodge or minimize unduly the facts which are against you. If one cannot win without doing this, and it is seldom he can by doing it, the case should not be appealed. That's from the Honorable Wiley B. Rutledge. Scrupulous accuracy consists not merely in never making a statement you know to be incorrect, that is mere honesty, but also in never making a statement you are not certain is correct. Scrupulous accuracy. not merely in never making a statement you know to be incorrect, but also never making a statement you are not certain is correct. So err, if you must, on the side of understatement and flee hyperbole, since absolute negatives are hard to prove and hence hard to be sure of. You should rarely permit yourself an unqualified never. Preface a clause like, such a suit has never been brought in this jurisdiction, with an introductory phase like, as far as we have been able to discover. Okay, so that's very nice. Instead of saying it's never been brought, say as far as we have been able to discover. That should be the preface. Such a suit has never been brought in this jurisdiction. Nice. Inaccuracies can result from either deliberate misstatement or carelessness. Either way, the advocate suffers a grave loss of credibility from which it's difficult to recover. If possible, number 7, if possible, lead with your strongest argument. So prioritizing, let's get into it. Okay, when logic permits, but your winning argument up front in your affirmative case. Why? Because first impressions are indelible. This is nice. When logic permits, put your winning argument up front in your affirmative case. Why? Because first impressions are indelible. Because when the first taste is bad, one is not eager to drink further. Because judicial attention will be highest at the outset. Because in oral argument, judges' questioning may prevent you from ever getting beyond your first point. Very interesting. Sometimes, of course, the imperatives of logical exposition demand that you first discuss a point that is not your strongest. For example, serious jurisdictional questions must be discussed first. It makes no sense to open with the merits and then to consider at the end whether the court has any business considering the merits. There is also a logical order of addressing merit issues. C may not be relevant unless B is established, which in turn is not relevant until A has been established. For example, you might have to prove that A, the agency, validly promulgated the regulation, B, the agency has interpreted the regulation to favor your client, and C, the agency's interpretation is entitled to judicial deference. Judicial deference. No other order of progression would make sense. Similarly, in defending a medical malpractice judgment on appeal, your argument portion would not begin by justifying the amount of the award and then proceed to defending the judgment of liability. If you're the appellant, even though logic has pushed your strongest argument toward the back of the line in your principal brief, bring it up front in your reply, which will often set the agenda for the oral argument. Great strategies here, once again. And if you're an appellant at an oral argument, begin with your strongest point regardless of what logical progression demands. See Section 81. If the court wants a logical progression at oral argument, it won't be shy about asking for you to turn to a logically prior point. And there, unlike in briefing or bridge, if you don't show your ace of trumps first, you may never get a chance to play it. So timing, prioritizing, what do we call it? The strongest argument first. Let's continue. Number 8, if you're the first to argue, make your positive case and then preemptively refute in the middle, not at the beginning or end. Wow, Interesting here too. It's an age-old rule of advocacy that the first to argue must refute in the middle, not at the beginning or the end. Refuting first puts you in a defensive posture. Refuting last leaves the audience focused on your opponent's arguments rather than your own. So, for the first to argue, refutation belongs in the middle. Aristotle observed that in court, one must begin by giving one's own proofs, and then meet those of the opposition by dissolving them and tearing them up before they are made. Interesting here. So you get this is from Aristotle. First to argue, refutation belongs in the middle. That's your opponent's argument. You don't want the beginning or the end. The beginning is the first impression, it's indelible. The end's the one that leaves a taste with them. You don't want them lingering with thinking about your opponent's arguments rather than your own. Anticipatory refutation is essential for 5 reasons. So that's anticipating what they're going to refute your points with. It's essential for 5 reasons. Here we go. First, get your notepad here. Any judge who thinks of these objections even before your opponent raises them will believe that you've overlooked the obvious problems with your argument. So the obvious objections you definitely want to take care of in your refutations here, right? Second, at least with respect to the obvious objections, responding only after your opponent raised them makes it seem as though you are reluctant rather than eager to confront them. Third, by systematically demolishing counter-arguments, you turn the tables and put your opponent on the defensive. This is good, number 3 here, right? By systematically demolishing counter-arguments. Systematically. You turn the tables and put your opponent on the defensive. Fourth, you seize the chance to introduce the opposing argument in your own terms, and thus to establish the context for later discussion. Finally, you seem more even-handed and trustworthy. Wow, 5 points. Take note. Every argument is refuted in one of these ways. Are you ready? Either one or more of its assumptions are not granted. Or if the assumptions are granted, it is denied that a conclusion follows from them. Or the form of argument is shown to be fallacious. Or a strong argument is met by one equally strong or stronger. Wow. That's from Cicero. Let's continue. But anticipatory refutation has its perils. You don't want to refute and thereby disclose an argument that your opponent wouldn't otherwise think of. Avoiding this pitfall requires good lawyerly judgment. So, again, hold your cards close to you. You don't want to give away a difficult argument, but you don't want to be reluctant to confront obvious arguments. Okay, so again, being even-handed and appearing trustworthy doesn't require you to dig so deep as to argue for your opponent, I think is what he's getting here. The anticipatory refutation should be limited to obvious arguments that would be posed, counter-arguments that would be posed by your opponent. 9. If you're arguing after your opponent, design the order of positive case and refutation to be most effective according to the nature of your opponent's argument. Let's see about that. Aristotle advised responding advocates to rebut forcefully in their opening words. If one speaks second, one must first address the opposite argument, refuting it and anti-syllogizing, and especially if it has gone down well. For just as the mind does not accept a subject of prejudice in advance, In the same way, neither does it accept a speech if the opponent seems to have spoken well. One must therefore make a space in the listener for the speech to come, and this will be done by demolishing the opponent's case, thus having put up a fight against either all or the greatest or most all right, or easily refuted points of the opponent. This is, I think this is the root here, is like speculous to see, or easily refuted points of the opponent. One should move onto one's own persuasive points. Translated from the Greek. So I guess the thing is, one must therefore make space in the listener for the speech to come, and this will be done by demolishing the opponent's case, having put up a fight against either all or the greatest. So we were previously suggested that we don't do all of them, just the greatest or most obvious or easily refuted points of the opponent. One should move on to one's own persuasive point. So there's your order again. So again, this is rebut forcefully in their opening words. So think about this, guys. This is important here. This is, again, that order, very simple order, 3 parts, right? And the middle part is going to be refuting it and then coming back to the end for the conclusion here. And let's see what else we have here. This point applies to those who oppose motions, to respondents, and to appellees. If an opponent has said something that seems compelling, you must quickly demolish that position to make space for your argument. Wow, this is a great concept here, guys, to make space for the argument, your argument. You don't want space to be occupied with theirs. You must demolish theirs to make space for yours. Here's our caution now. As a general matter, this advice applies to refutation of separate points that make your affirmative points academic, not your opponent's contesting of your affirmative points themselves. All right, see here. If, for example, your case rests on the proposition that a particular statute creates a claim, you would not begin by refuting your opponent's argument that no claim was created. You would present your own affirmative case to the contrary first. Suppose, however, that your opponent has argued quite persuasively that the court lacks jurisdiction, and that the statute of limitations on any claim has expired. Judges don't like to do any more work than is necessary. If they have a fair notion that they will ever have to reach the question whether a claim was created, they aren't going to pay close attention to your oral argument on that point. And we have known judges to skip entirely over the merits section of an appellee's brief to reach the response to the appellate's jurisdictional or other non-merits argument. Again, the jurisdiction should be established first, right? First order. You must clear the underbrush, or as Aristotle puts it, make space, so that the court will be receptive to your principal argument. Having made that space, however, you must then fill it. Proceed quickly to a discussion of your take on the case, your major premise, and your version of the central facts, as put by a perceptive observer in the context of an appellee's argument. Here we go. Nothing could be more serious. Starting over here. Nothing could be a more serious mistake than merely to answer the arguments made by counsel for the appellant. These arguments may be skillfully designed to lead counsel for the respondent off into the woods, or they may lead him there unintentionally. The proper line of attack for counsel for the respondent to adopt is to proceed to demonstrate by his discussion of the law and the facts that the judgment is right and that it should be affirmed. All other considerations are secondary. So again, even if you're not the appellant, if an appeals be made against your case, these are the chinks in the armor you would look for on the other side. Did they do all this properly? If not, then who knows? Yeah, it'd be great if we get to 15 likes. Let's get the likes up there, guys. If there's enough people in here, this is important information for us to all know. I'm not the biggest fan or advocate of the late Justice Scalia. However, you can't discount the man's knowledge and wisdom for all the years that he has been performing on the bench. So it's take it or leave it what you get from this, but I think it's hard to overlook the kind of wisdom that someone of that stature and achievement has can offer us, especially in his writings, which he does have rather a easy to read style. And I'm going to make this easier to read by making the print bigger. I just realized how small it was for the audience there. All right, let's continue. All right, we're on to number 10. Occupy the most defensible terrain. We're going to go ahead and go over this part here. We're going to be cutting it short soon because I don't want to overrun everyone too much, but let's just end on this one here because this is a good point to end on. So occupy the most defensible terrain. Select the most easily defensible position that favors your client. I'm a little too big on the screen now. Hang on, let me make this a little smaller here. Apologies. All right, let's proceed. Select the most easily defensible position that favors your client. Don't assume more of a burden than you must. If, for example, a leading case comes out differently from your desired result, don't argue that it should be overruled if there is a reasonable basis for distinguishing it. If you're arguing for a new rule in a case of first impression, frame a narrow rule that is consistent with a judgment for your client. Why set yourself the task of providing a satisfactory answer to 100 hypothetical questions about the multifarious effects of a broad rule when you can limit the questions to 5 about the limit effects of a narrow one? You get this? We're talking about defensible terrain. Don't argue that it should be overruled if there's a reasonable basis for distinguishing it. So we don't want to make more of a burden than we must, right? You don't want to deal with 100 hypothetical questions if you could limit it to 5 by narrowing, right? Narrowing the rule that is consistent with your judgment for your client. If the defendant has intentionally injured your client in some novel fashion, argue for the existence of some hitherto unrecognized intentional tort, not for a rule that includes negligent acts as well. Let's read this here. If your court is divided philosophically, your best bet is to strive for a narrow, fact-bound ruling that will not force 1 or 2 judges to revisit old battles or reopen old wounds. You want to win unanimously. You do not want a messy dissent to provoke a petition for an en banc or even certiorari. On a divided court, a big forward or backward, depending on your point of view, leaps in the law come usually only in en bancs, or if they do come in a panel, often end up in banks. Take your narrow, for this case only, holding, hug it to your bosom, and run. All right, so we're talking about benches here. Taking the high ground does not mean being non-committal. Saying, for example, that you win under any of 3 different possible rules, without taking a position about which rule is best. The judge writing an opinion, especially an appellate judge, cannot indulge in that luxury, but must say what the law is. Be helpful. Sure, point out that you win under various rules, but specify what the rule ought to be. This is in novel cases, right? If you fail to do that, you leave the impression that all your proposed rules are problematic. Don't let your adversary's vehement attacks on your moderate position drive you to less defensible ground. Vehement attacks, don't let that change your defensible ground position. If, for example, your position is that an earlier case is distinguishable, you know what this means is that an earlier case is different than yours, right? Don't get muscled into suggesting that it be overruled, right? And don't let your adversary get away with recharacterizing your position to make it more extreme, a common ploy. If you are arguing, for example, that lawful resident aliens are entitled to certain government benefits, don't leave unanswered your opponent's suggestion that you would reward illegal aliens. Respond at the first opportunity. Okay. So this is where you want to look at, though. Someone's arguing that lawful resident aliens are entitled to certain government benefits. Don't leave unanswered your opponent's suggestion that you would reward illegal aliens. Respond at the first opportunity. So they're not, if you don't answer that and it's left out into the open, then that's usually a way for people to start speculating and assuming, making assumptions that perhaps you will be doing something that you didn't state you were going to do, but you didn't deny it either. So yeah, I can see how that could open up the opportunity for others to take advantage of a weakness there of argument. On rare occasions, not that I advocate any of this, but I'm just saying in the hypothetical context of these arguments here. On rare occasions, it may be the institutional interest of your client to argue for a broader rule than is necessary to win the case at hand. When you take this tack, the court is likely to ask why it should go so far when a much narrower holding will dispose of the case. Have an answer. And there we are. So we'll continue next time on yield indefensible terrain ostentatiously. So this will leave us on a good place to resume for the next one on section 11. So I want to thank everybody for coming here tonight. This has been a great educational, inspiring, and somewhat entertaining, especially with the style of these authors here, giving us a good presentation with experience and wisdom of a lot of jurisdictional experience, and also within the context of common law, constitutional law, municipal, civil, criminal. We get the whole gamut here. So invaluable for the people here in the United States of America to know, especially the fact that we still have access to this kind of power, and it behooves us to learn it. And I salute you all for being here to participate in this process. And I hope to see you all on the next one. Please make sure you hit that bell notification so you're subscribed, and you'll get notified so we can continue this on part 3 next time. I'll see you all then. Peace out.